Welcome back to Reignited. My name is Sky, and almost 3 years ago, I posted a video about a Hemi lawsuit that was brought against what at the time was called Fiat Chrysler. Well, it's been 3 years. What's going on with that lawsuit? Is there anything new to report? Well, I'm going to give you all the latest in this episode, and there's some really interesting stuff in here. Just a couple quick disclaimers here. I have no legal training whatsoever at all. That is not my field. My background is I'm a professional mechanic. I've been in tech for the last 15 years. So that's where my expertise lies. And I can kind of maybe give you guys a little bit of insight into what I think is going on with this lawsuit on that aspect of things. Now, secondly, I'm not picking a side here. I don't care if this side wins or if this side wins. It doesn't matter to me at all. I'm just relaying this information to you guys. Now, if you haven't had a chance to watch that video I did 3 years ago, I highly recommend you watch that video first before watching this one. So I'm going to go ahead and link it right here and also in the description down below. And I discuss a few of the reasons why I think it's very difficult for this lawsuit to be successful. But in this video, we're covering what has happened since that time, since they brought the lawsuit. There's been a little bit of bantering back and forth here. And basically, the defense, Fiat Chrysler, has come up with a motion to dismiss, and there's several reasons that they listed why this case should be dismissed. Kind of seems like standard procedure in a case like this. Now, the plaintiffs offered a rebuttal to all of those reasons, and what we have here is the judge's opinion or their memorandum opinion on all of these motions to dismiss. Now, I will say right up front that some portions of the motion to dismiss were granted, and some of the portions of the motion to dismiss were rejected. So we're going to cover those in greater detail. Now, just before we get started, I want to acknowledge that your guys' time is very important. And I understand that a lot of you don't have the time to sit through this entire video to really look at all the nuance that's happening here, because there is a lot of legal intricacies happening here. And while I find it fascinating, and I think that you should watch the whole video, if you don't have the time to do that, I completely understand, and you want to skip forward to the part that has the most pertinent effect on this particular lawsuit, I will put the timestamp on the screen right now where you can jump forward and watch that. And just so you guys are aware that this opinion piece that I'm reading from here is publicly available online. If you want to look it up, I'll go ahead and link that in the description down below as well, so you can read through this in its entirety if you have any questions for yourself that you want to kind of dive further into. We're going to start off here right at the very beginning, because I think it's important to actually figure out what it is that these plaintiffs are actually alleging against FCA. So let's take a look. It says that FCA is a vehicle manufacturer. We know this. They're talking about all Dodge, Jeep, Ram, Chrysler branded vehicles model years 2014 to present, equipped with a Gen 3 5.7 liter Hemi or a 6.4 liter Hemi engine. Now, the named plaintiffs have each purchased one of these vehicles. The plaintiffs allege that the class vehicles have a design flaw that makes these vehicles dangerous to operate. Specifically, they contend that the class vehicles incorporate FCA's multi-displacement system, valve train technology. Plaintiffs allege that the design, manufacturing, material, and workmanship of the system is flawed, and those flaws cause the lifters, camshafts, rocker arms, valve springs, and other related components of these class vehicles, the 5.7 and 6.4s, to malfunction and fail prematurely. Plaintiffs further contend that FCA was aware of the defect but actively concealed it from the plaintiffs and certain dealerships that sell these FCA vehicles. The named plaintiffs in this suit are Stephen Freischlag, Orlando Garcia, David Kinchin, Sean Petro, and Troy Stallings. Now, this is important because these people live in different states. So basically, when you're trying this lawsuit, each of those states have different laws about how this lawsuit can proceed. So that's something that actually has an impact on what we're going to see in this opinion. I'm going to talk just a little bit more about the plaintiffs, their vehicles that they had, and also the problems that they had with those vehicles, because I find it really is important later in the video. Okay, the first one we're going to talk about here is Stephen Freischlag. He's a New Hampshire resident who purchased a new 2017 Ram 1500. At 80,000 miles, he brought his vehicle to the dealership for a ticking noise. The technician found that the valve lifters were twisted and replaced them. At 82,000 miles, he brought it back to the dealership because the ticking noise he felt was even louder, and the technician replaced an exhaust manifold gasket. So I have a problem with the way that this is written, and that's just because, these are lawyers, they're not mechanics, so they don't know the nuance behind it. But I feel like this is actually working against your own goals when you say, oh, the technician found it was lifters, and then they brought it back 2,000 miles later and said, oh, it's an exhaust manifold this time. So Kind of working against your own means here. I suspect the actual events were slightly different, but that's probably the wording that they got on the final service order or service repair order. Okay, next, Orlando Garcia is a Texas resident who purchased a new 2016 Ram 1500. At around 57,000 miles, he took his vehicle to the dealership because of a loud clicking noise was coming from the hood and the vehicle was shaking. The dealership found that an intake valve spring and a push rod were bent and replaced those components. Garcia's vehicle still ticks. Once again, kind of an issue with the way that there's a wording here saying that the intake valve spring and push rod were bent. My guess is the intake valve spring broke and that actually bent a push rod. That's why the engine was shaking, because it was misfiring. So again, you're kind of working at cross purposes here, because now you've got a failed valve spring, which to me doesn't have anything to do whatsoever at all with lifters. But then they tack on at the end that Garcia's vehicle still ticks. Well, in my experience, when you have a broken valve spring and you've got a bent push rod, once you replace those components, the vehicle runs perfectly fine with no issue whatsoever. So if it is still ticking, it's probably an entirely separate issue that could be related to cam and lifters, but it's not related to what was actually fixed on this vehicle. So anyway, moving on. David Kinchin is a Louisiana resident who purchased a new 2016 Ram 1500. He noticed that the engine and lifters were tapping a day after purchasing the vehicle. He called the dealership, who told him that the issues with the lifters were normal. At around 15,000 miles, he brought it in 3 different times to the dealership and asked them to diagnose the excessive engine noise. The dealership told him that his vehicle was operating as intended each time. Again, this is a tough one because maybe there was in fact an issue happening, but it is my opinion that most of the Hemi engines that we see, if you leave them sit for like 2 or 3 days, on that initial startup, you'll definitely hear some lifter noise. They rattle a little bit. That's even on brand spanking new vehicles that just come in. However, if it was still making the noise when the vehicle was warm, the engine was hot, that sort of thing, then yeah, there's another issue that should have been investigated further. But I do want to clarify, you guys know that my channel, I've focused a ton of time on these cam and lifter issues. Most of the time, these lifter issues will not present themselves that early in the vehicle life. He's talking 15,000 miles. I would say 98% of the time that you would have at least 60,000 miles on the vehicle, if not much more than that, before these lifter roller failures will occur. Okay, next up, Sean Petro is an Illinois resident who purchased a new 2020 Ram 2500. At about 7,000 miles, Petro heard ticking noises coming from the engine. He took the vehicle to a dealership who told him that those sounds were normal. At 19,000 miles, the dealership replaced the lifters. This very much sounds to me like he was just aggressive with the service department saying something is wrong, fix it, fix it, fix it, and then the dealership just went ahead and put lifters in it because we know that they can be an issue with these vehicles. So they said, okay, fine, we'll throw a set of lifters at it and see what happens. That to me, that's how I'm interpreting it, having been in the industry for as long as I have. Again, actual roller lifter failure does not happen this early in the vehicle lifetime. Okay, last one. Troy Stallings is an Illinois resident who purchased a new 2014 Ram 3500. At 70,000 miles, the engine failed while driving, and a third-party dealership installed a new long block. So he said, hey, this thing just went kaput on me at 70,000 miles, and I had to put a brand new engine in it. That's probably the most clear-cut case that I could say, yeah, that's probably exactly how it went down. Okay, now onto their actual complaint. It says the plaintiffs filed this action seeking national class certification for all purchasers of an asserted vehicle. Plaintiffs also seek certification for 4 state-based subclasses for purchasers of an asserted vehicle in those states, namely Illinois, Louisiana, New Hampshire, and Texas. On behalf of the nationwide class, plaintiffs allege fraudulent concealment, unjust enrichment, and violation of the Magnus-Moss Warranty Act. On behalf of the state subclasses, plaintiffs allege violations of the Illinois Consumer Fraud and Deceptive Business Practices Act, Louisiana Product Liability Act, and Texas Deceptive Trade Practices Act, as well as claims for breach of express and implied warranties. Now here's where I feel like they kind of shot themselves in the foot, and again, it goes back to my original video on why I said that this was going to be a very difficult lawsuit to win, and that is that all of their experiences and the repairs on their vehicle were markedly different from one another. Different scenarios, different things that have actually failed. Now, What we're talking about as the core of this video is cam and lifter failures that we're seeing on the Hemis. And there's, of course, no denying that that is the case. I have done quite a great many of those myself, and we understand that it is an issue. I've done so many videos talking about that issue and what I believe to be the root cause. However, this group of people did not specifically have that lifter roller failure that we're seeing with the cam lobes being ground into. Maybe one of them did, but they're all having slightly different experiences. That makes it really difficult to actually press the case that this in particular is the problem. So I kind of wish that they had gotten together a few more people that have directly had the cam and lifter issues specifically, and then you could say that, hey, there's a trend here that all of these are having the exact same problem. Now, I know that some of you out there will say, well, you're talking semantics because they're all dealing with valve train issues. Yes, we are talking semantics, but again, we're also talking about the legal system, and specifics are extremely important here. And I'm just saying that from my standpoint as a mechanic, I'm not going to look at those situations and correlate them all into the same issue. However, if you had 5 people or 10 people or 1,000 people who experienced the exact same issue with their engine and had to have the exact same parts replaced, that's another matter entirely. So I kind of wish they had consolidated that a little bit better. Now, the attorneys for the FCA had then filed a motion to dismiss this case. Now, they listed several reasons as to why the case should be dismissed. I'm going to read those here. Number 1, plaintiffs lack standing to assert a nationwide class and lack standing to pursue claims for vehicles they did not purchase. Number 2, some of the plaintiffs' claims are subject to the heightened pleading standard of Federal Revision something blah 9B and fail to meet that standard. We'll discuss that later. Number 3, plaintiffs' unjust enrichment claim fails because of an express warranty. Number 4, plaintiff's express warranty claim fails because the plaintiffs are suing over a non-covered design defect. Number 5, plaintiffs' implied warranty claims fail because the class vehicles are merchantable. Again, discuss that later. Number 6, plaintiffs' Magnus-Moss Warranty Act claim fail because the plaintiffs' implied and express warranty claims fail. And number 7, plaintiff's Louisiana Product Something or Other Act claim is time barred. So a variety of reasons are saying why this lawsuit should be thrown out. That's entirely what this opinion from the judge is written about. He's ruling on every single one of those things. So we're going to go over those one by one. Now, the first motion the FCA had here says, and lacks standing to pursue claims for vehicles they did not purchase. What they're saying is, you're a small group of people, you've only purchased this small group of vehicles. How could you possibly say that what you're suing us for affects all of these different vehicles and all these different brands that you haven't even owned before? And the plaintiffs are saying, well, we believe the issue is integral to the Hemi 5.7 and 6.4 engine. So essentially, any vehicle that's equipped with that engine should be covered under this lawsuit. And the judge was actually pretty favorable to that. He said, hey, this is a precedent we've seen before. He lists that there in the opinion. He said this is something that FCA will have a chance to argue later on, but at this time, the motion to dismiss for this reason is denied. The next point the FCA lawyers have on their motion to dismiss is a little bit confusing, but I'm going to try to break it down based on what I have here. But it says that some of the plaintiff's claims are subject to heightened pleading standard 9B. So they are saying that the plaintiffs have not adequately pleaded that FCA made a material misrepresentation, omission, or concealment of fact, shown reliance on a statement made by FCA, and shown FCA knew about the alleged defect of the class vehicles prior to selling those vehicles to the plaintiffs. Now, under this rule 9B, a party asserting a fraud claim must state with particularity the circumstances constituting fraud or mistake. To satisfy this rule, the complaint must allege the who, what, when, where, and how of the events at issue. Now, the judge very clearly refutes these claims in his opinion here. It says, the complaint pleads specific facts to support the plaintiff's fraudulent misrepresentation claims by citing specific advertisements and brochures, the where and when, in which FCA, the who, touted the reliability, capability, and durability of the system, the what and the how. Plaintiffs plead that the individual plaintiffs reviewed the advertisements and relied on the affirmative misrepresentations. Now, they also allege that rather than being capable over the long run, the class vehicles stop functioning. Thus, plaintiffs have alleged the FCA made affirmative misrepresentations. The plaintiffs have also adequately pleaded omissions and concealment. While omissions claims are also subject to Rule 9b, the pleading standard is relaxed for fraudulent omissions because a plaintiff in a fraud by omission suit will not be able to specify the time, place, and specific content of an omission as precisely as would a plaintiff in a false representation claim. Now, he also cites some previous cases that cover this. It says, moreover, in product liability cases, courts typically assume that the omitted information was material to the plaintiff's decision to purchase the product if the alleged defects create unreasonable safety risks. Now here, the plaintiffs allege the FCA omitted any pre-sale mention of the defect, its nature, and its causes. The plaintiffs plead that they reviewed advertising material, relied on the omission, and would not have purchased their vehicles or would have paid less if that defect had been disclosed. The plaintiffs allege the FCA had exclusive and superior knowledge of the defect and that it was not known or reasonably discoverable by the plaintiffs. They add that the defects creates a serious safety concern, including loss of power while driving. Taken together, these allegations are sufficient to state a claim of fraudulent omission. Now, because the plaintiffs allege that the defect caused safety concerns, the court will assume that FCA's omission was material to each class member's decision to purchase their respective vehicles. Further, given plaintiffs' claims the FCA had superior and exclusive knowledge of the defect, the court finds plaintiffs' allegations sufficient to support their fraud by omissions claims. So, this motion as well was denied. Now, the next thing that the FCA lawyers are trying to say here is that the plaintiffs failed to plead the FCA had any pre-sale knowledge about this issue, and this is important, of vehicles sold to customers by November 2014. Remember that this class involves vehicles from 2014 onward. And again, such a strange choice to me that they chose 2014. I don't know why they did that, because we've seen these lifter issues prevalent in the engine all the way back to 2009. So still don't understand why they chose 2014 and onward. There has to be some reason why they did that. But regardless, lawyers are saying, hey, you can't prove that FCA knew anything about this issue before that time. Well, the plaintiffs respond and say that FCA issued a STAR case report in September of 2017. Now, to clarify for you guys, STAR is our technical assistance line. If you don't know, I'm a factory Dodge technician, and STAR is our technical assistance line. They're who we talk to if we have an issue that maybe we can't quite figure out what's going on, or we need some additional information that's not available to us through regular service information. So we talk to these guys, we try to figure out a solution, and if enough of those issues come up, oftentimes they will issue basically a STAR case report. So we can look it up and see, hey, we're having this issue. Is there any information about that? And STAR can issue a report like this that says, hey, if you're having the same problem, maybe look at this as a potential cause. That's what was issued here in 2017. I want to clarify that I believe there is an actual difference between a STAR case report and a service bulletin. My thought is that potentially service bulletins are available to be viewed publicly while STAR case reports are not, but I'm not sure what the standard is for it to rise to a service bulletin. But again, this is a STAR case report. There is a difference. Now, the plaintiffs also allege that on top of this STAR case report, there's also complaints that consumers submitted to the NHTSA, so the National Highway Transportation Safety Administration, regarding this same defect. And they're saying the FCA conducted internal testing both pre-release and in response to consumer complaints. Now, the opinion reads that for the following reasons, the court agrees with the plaintiffs that their allegations taken in concert are sufficient to impute pre-sale knowledge to FCA. Now, it says that under that Rule 9b, malice, intent, knowledge, and other conditions of the person's mind may be alleged generally. Although Rule 9b permits knowledge to be averred generally, plaintiffs must still plead the events which they claim give rise to an inference of knowledge. So, and then he lists this previous case that lists that. It says, with respect to the STAR case report, FCA contends that it was issued well after every other plaintiff other than Petro had purchased their vehicles. While the court recognizes that some plaintiffs purchased vehicles before FCA issued that STAR case in 2017, This fact alone does not defeat the plaintiff's claims that the 2017 Starcase report evidences FCA's pre-sale knowledge. Indeed, courts have recognized that service bulletins issued post-sale may support an inference of the seller's pre-sale knowledge of the defect. And the judge goes on to list another court case here where it says that the court explained that post-sale service bulletins may evidence pre-sale knowledge because a manufacturer must receive complaints or data arising from an issue and then investigate the issue before issuing a service bulletin. Now, because this process can span several months, the court found it reasonable to infer that manufacturers know the issue prior to the release of the service bulletin. So, the court here then agrees with that court's reasoning and finds that service bulletins issued post-sale may provide evidence of a manufacturer's pre-sale knowledge. It says, nonetheless, the window of time between the sale and the date in which the service bulletin is issued must be reasonable, and a service bulletin issued long after purchase lends little support to the necessary inference of knowledge. So kind of hedging both directions on this one. It says, similarly here, the complaint asserts that the earliest purchases by a named plaintiff were made in November 2014, approximately, there we go, November 2014. That's why they chose 2014, was because the earliest date of the person who is actually part of the lawsuit purchased his in November 2014. Makes more sense now. So he made his purchase in November 2014, approximately 3 years before the 2017 Starcase report, while the last consumer purchase was in April 2021, 4 years after the Starcase report. Given the high probability that the Starcase report followed months of research and investigation by FCA, the court finds that the plaintiffs can rely on the post-sale Starcase report as one piece of evidence of FCA's pre-sale knowledge of the defect. Now, another rebuttal that FCA had was they contend that the 2017 Starcase report cannot impute pre-sale knowledge to FCA because of the discrepancy between the plaintiff's alleged experiences and the content of the service bulletin. And in that, I fully agree with them. It's like I already talked about. Most of these guys, some of them had their lifters replaced, but I'm not going to sit here and tell you that it's because they had the roller failure that was mentioned in this Starcase. In fact, let's take a look here at some more details of the Starcase. It says the Starcase report related to abnormal engine noise, rough idle, lack of power, and misfires potentially due to camshaft lobe wear or lifter wear, roller failure on one or more cam lobes. Plaintiffs complained of a ticking, knocking, or tapping noise and identified camshaft lobe or lifter wear as the primary cause. Again, these are vehicles, a lot of them were vehicles with relatively low miles that probably were not even experiencing this exact failure. There are many other things that can actually cause the sort of ticking and knocking noises that they were having. And I'm sure all of you guys are killing me in the comments right now saying, you know there's a problem. Yes, I agree. There is a cam lifter problem. I'm saying that these particular individuals were the wrong ones to bring the lawsuit because they were not experiencing the exact failure of the cam and lifters as we know it. So it's just kind of a frustration for me that these are the ones who actually came together to start the lawsuit because their experiences were not consistent with the actual cam and lifter failures that we're seeing consistently on these Hemi engines. But even with that being the case, note what the judge writes in his opinion here. He says, construing these allegations in favor of the plaintiffs, the court finds that the service bulletin sufficiently relates to the defect alleged in the complaint. So I find that interesting only because it being my industry, I know a little bit more about it and I feel like I could easily refute these sorts of things. But to a non-mechanic person like the judge, he said, hey, these things sound similar enough to say what they're talking about, so therefore I'm going to allow it. Now, in addition to this, FCA is also stating that the complaints that the NHTSA has received about this defect shouldn't be included either as pre-sale knowledge by FCA because several of these complaints predate the purchases. And the symptoms are too distinct from what the plaintiffs experienced. So very similar type of argument there. The plaintiffs cite the NHTSA complaints predating the earliest sale and dating back to 2011. It says, while the court agrees with FCA that a mere handful of complaints is insufficient, in this case, the court cannot view the complaints independently from the plaintiff's remaining allegations regarding FCA's pre-sale knowledge. Rather, at the pleading stage, courts must consider the complaint in its entirety and determine whether the complaint as a whole contains sufficient factual matter to state a facially plausible claim. A lot of words there. It says, thus here, the 4 NHTSA complaints predating the plaintiff's purchases must be viewed alongside FCA's 2017 Star Case report. When viewed together with the plaintiff's detailed allegations of internal testing, the complaints and the 2017 Star Case report adequately support the plaintiff's claims that FCA had pre-sale knowledge of the defect. Again, keep in mind that these are all preliminary things, and we're just striking down different portions of this motion to dismiss. All the court is saying at this point is we're finding enough evidence at this time to proceed with this lawsuit. Okay, to this point, most of these have been relatively straightforward, but now we kind of get down into the weeds a little bit. And if I am making mistakes of a legal variety, please, any of you who are lawyers, feel free to set me straight down in the comments down below. I will pin your comment. That way more people can see it and get that clarification that they need. So the next point here, it says, plaintiff's state law fraud complaints must be dismissed for failure to allege a special relationship of trust that would require disclosure. What in the world are they talking about there? Well, again, because this lawsuit covers multiple different states, there's different laws that apply. As FCA concedes, Illinois does not require a special relationship of trust. On the other hand, Texas, Louisiana, and New Hampshire require such a relationship. It goes on to cite a number of different legal precedent cases. It says plaintiffs allege a defect impacting safety, creating a risk of injury for all plaintiffs, including one plaintiff whose vehicle actually did stall. Now, plaintiffs' allegations therefore suffice to create a duty to disclose under Texas law. New Hampshire recognizes a duty to disclose where one party has superior knowledge of a material fact. Louisiana finds a duty to disclose when the defendant makes a partial or incomplete disclosure about its product. Plaintiffs' allegations that FCA had superior, exclusive knowledge and failed to disclose a known danger thus suffice to create a duty to disclose under New Hampshire or Louisiana law. For our next point, plaintiffs' fraud claims are barred by the statute of limitations. So FCA here is contending that it's barred by that statute of limitations. Plaintiffs respond that the doctrines of delayed accrual or equitable tolling apply. Gotta be honest, I don't know what either of those means, but essentially, they kind of break it down in a way that says, the plaintiffs allege that FCA concealed the claims by directing dealers to tell plaintiffs that the strange noises were normal and would require no repairs. It says, at this stage, this is sufficient to allege fraudulent concealment. Now, with that being the case, plaintiffs had pleaded that they did not discover the defect until between 2017 and 2022. At this stage, the court must accept these allegations as true. To the extent the FCA suggests that the plaintiffs should have discovered the defect via certain public information, the court may not draw those inferences in favor of the defendant at this stage of the litigation. Thus, the court will not dismiss plaintiffs' claims for being time barred. I do think that this was kind of a funny argument by the lawyers for FCA, that they're like, well, you should have just done your research about it before you bought the product, and then you would have known, so you can't blame us. I think that's a pretty funny way to present your argument, but I guess it is one legal alternative to get them out of it. Now, this next one is state-specific. It says that the plaintiff's New Hampshire claims fail for lack of privity. Now, I had to look that up. I didn't know what that was. It says privity. If a third party gets a benefit under a contract, it does not have the right to go against the parties to the contract beyond its entitlement to a benefit. Does that clear things up, right? It's totally clear. But it says an example of this occurs when a manufacturer sells a product to a distributor and the distributor sells the product to a retailer. The retailer then sells the product to a consumer. There is no privity of contract between the manufacturer and the consumer. So in my mind, what this is saying is that because the manufacturer just builds the vehicles and then it's the dealer who sells them to the consumer, that the consumer does not then have the right to go against the manufacturer, which seems really weird that that would be a thing that's possible, but I guess potentially it is. However, in this particular case, the opinion reads that New Hampshire does not require privity where a duty to disclose may flow to any foreseeable and intended third-party beneficiary of the contractual duty. So plaintiffs have alleged that they are third-party beneficiaries of such a duty. Makes sense. It says, thus, plaintiffs' New Hampshire claims do not fail for a lack of privity. So yet another thing that was struck down by the judge. Now, the next thing FCA was asking the court was to dismiss their fraudulent concealment claims for the New Hampshire, Louisiana, and Texas subclasses on the grounds that those states apply the economic loss doctrine. Now, I do have some information on that. It says, the economic losses refer to financial loss and damage suffered by a person such as can only be seen on a balance sheet rather than as a physical injury to the person or property. For example, if a new car breaks down but nobody is injured and the only loss is a diminished value of the non-functioning vehicle, those are considered to be purely economic losses. Now, the plaintiff's rebuttal to that is that they contend that their claims survive dismissal because states in those jurisdictions have adopted exceptions to the economic loss doctrine that apply here. It says, in New Hampshire, the economic loss doctrine does not bar claims of misrepresentation and fraudulent inducement. Similarly, Texas courts have permitted cases of fraudulent omission to be brought notwithstanding the economic loss doctrine. And plaintiffs allege that FCA concealed material information for the purpose of inducing plaintiffs and class members to purchase or lease the class vehicles. Thus, plaintiffs' claims under Texas and New Hampshire law are not barred by the economic loss doctrine at this time. To the extent the FCA contends that any fraud was in the performance of the contract rather than its creation, FCA has not met its burden at this time. It is plausible from the face of the complaint that plaintiffs' claims go to the inducement of the contract rather than the performance of it. So, it says, accordingly, FCA's motion to dismiss plaintiffs' fraud-based misrepresentation and omissions claims is denied. This next section, I want to be as clear as I can, and I'm going to read it almost verbatim here because this is an area where the judge actually agreed with FCA and did not agree with the plaintiffs, so I just want to be super clear about this one. It says, FCA moves to dismiss plaintiffs' claims for unjust enrichment on grounds that such claims are precluded by the existence of an express warranty. Now, unjust enrichment. It says, when someone is said to have been unjustly enriched, this means that he is benefited at someone else's expense due to chance or mistake. In such situations, the law of equity demands that the enriched party make restitution to the person who was injured. Examples of unjust enrichment are typically found in breach of contract lawsuits. Like the situation presented above, unjust enrichment usually results in situations where one party receives services or goods that is considered to be unfair. Plaintiffs do not dispute that their vehicle's express warranties govern the parties' rights, and they have not pleaded that they do not have adequate remedies at law. So while plaintiffs may seek equitable relief as an alternative to legal damage, in doing so, plaintiffs must allege that legal remedies would not adequately compensate plaintiffs for their damages. Thus, FCA's motion to dismiss plaintiffs' claims for unjust enrichment must be granted under each of the applicable state laws. Similarly, plaintiffs must plead that FCA's conduct is not covered by the express warranties in order to bring an unjust enrichment claim. So that was the judge's decision, and at this time it says the plaintiffs request leave to amend. FCA does not oppose. So basically they just kind of want to rewrite it a little bit, maybe do a little bit more research on that and figure out if this unjust enrichment is something that they can still make stick in the lawsuit moving forward. If not, they'll just drop it and continue on with these other points. Now this next one is a tough one, and it's one that I fully believe to be quite underhanded. I didn't even realize that this was a legal thing that you could do, but in this case, it says that FCA asks the court to dismiss the plaintiff's express warranty claims because the plaintiff fails to allege a breach of the warranties. Now, when we're talking about express warranty, it says an express warranty is an agreement by the seller to provide repairs or a replacement for a faulty product, component, or a service within a specified time period after it was purchased. Buyers rely on these promises or guarantees and sometimes purchase items because of them. Makes sense, right? Well, it says here that express warranties cover only defects in material, workmanship, or factory preparation. Plaintiffs' claims are based on a design defect. While plaintiffs state that a defect is caused by design, manufacturing, material, and/or workmanship, the court agrees with FCA that the allegations in the complaint make clear that the alleged defect is one of design and not manufacture or workmanship. That's pretty cold-blooded right there. I did not realize that it would not cover an actual design flaw. It's something I've dealt with throughout my career, where customers are very upset with the way something performs on their vehicle, and they're like, well, why don't they just make it better? And I say, I agree with you. This is a terrible design. I wish they would design it differently, but I have no control over that. Man, it's the same. I did not realize that within a warranty that you cannot actually come against the manufacturer for something that's just straight up a bad design. That's crazy to me. It only covers the actual materials and workmanship. And also, this comes back to what I was talking about earlier about semantics being very important about what you're saying the actual cause of the issue is, because they are alleging that this is a design flaw of the MDS system. Whereas, if you are familiar with my channel and my videos, you will know that my feeling is that we're dealing with more so bad quality of components between the cam and lifters themselves. So if they just stuck with that route and said, hey, your problem is the materials quality of the camshaft and lifters, they would have a stronger argument than what they're actually doing, which is saying that there's a defect within the design of the MDS system. So an interesting thing, like I said, semantics, but semantics in this case, very, very important. And as the court goes on further to explain in the opinion, it says, indeed, plaintiff's allegations of manufacturing defects go no further than the conclusory statement that there may be a manufacturing defect, and plaintiffs allege that the defect is due to a specially designed multi-displacement system present in every engine, that the defect plagues all vehicles equally, and that the defect is inherent and uniform. These allegations are highly specific and expressly allege that the design and specifications for collateral integral components of the MDS do not take into account the stress cylinder deactivation places on these components. Again, my feeling is that was a mistake to focus so heavily on that. It says, moreover, plaintiffs do not allege that their vehicles perform differently from other ostensibly identical units of the same product line, but instead allege that the product is built in accordance with its intended specifications, but the design itself is inherently defective. In light of these allegations, the court agrees that the complaint pleads only an uncovered design defect. Therefore, plaintiffs' express warranty claims fail. Accordingly, FCA's motion to dismiss plaintiffs' claims for breach of express warranty is granted. In my mind, this is a really big component of this case, and I feel like that was a pretty big blow. The next point the FCA lawyers had put out is they want to dismiss the implied warranty claims on the grounds that the plaintiffs have not pleaded that their vehicles were unmerchantable and that those claims are time barred. Well, to be merchantable means fit for the ordinary purposes for which that good is used. Ordinary car buyers expect that a car provides transportation in a reasonably safe and reliable manner. Plaintiffs have pleaded that the defect causes critical components of the vehicle to fail, true, creating a safety risk for plaintiffs and requiring costly repairs. They absolutely require costly repairs. While FCA suggests that the only harm plaintiffs have alleged is a ticking noise, plaintiffs have also alleged that their vehicles ran rough, would not start, and failed while driving. There is at least a fact question as to whether a car with an elevated risk of failure while driving is fit for its ordinary purpose. Thus, plaintiffs have adequately pleaded unmerchantability. FCA suggests that the plaintiff's claims under Illinois law fail for lack of privity. Now, this is something we talked about earlier, where basically the consumer is the one who purchases the vehicle, the dealership is the intermediary, and the manufacturer, the one who builds the product, then cannot be held liable by the consumer for whatever it built, that sort of thing. Well, they fight back on that again here. Plaintiffs allege both that they had direct contact with FCA and that consumers were an intended third-party beneficiary of contracts FCA made with its dealers. I totally agree with that. That absolutely makes sense. You're buying a manufactured vehicle from a dealership. You fully believe that the manufacturer is going to be the one to stand behind those warranty claims and not the dealership themselves. Now, while FCA contends that these allegations are conclusory, when taken as true, plaintiffs' allegations set out detailed allegations of direct contact via the warranties. Whether a manufacturer is in privity with a consumer is a fact-intensive question in vehicle cases. At this stage, plaintiffs' non-conclusory allegations are sufficient to survive dismissal. So, accordingly, FCA's motion to dismiss the plaintiff's claims for a breach of implied warranty is denied. The next point is very straightforward. It involves both the implied and express warranties we talked about earlier as far as it regards to the Magnus-Moss Warranty Act. And the opinion states that the plaintiff's Magnus-Moss Warranty Act claim rises and falls within its state law warranty claims. Thus, for those reasons we've already talked about before, FCA's motion to dismiss plaintiff's Magnus-Moss Warranty Act claim is denied. Now, this next point is another state-specific claim, and it involves the LPLA, which is the Louisiana Products Liability Act. It's very similar to these other ones that we've already discussed. And basically, they say that the plaintiff's LPLA claim should be dismissed because that claim is time-barred and because plaintiffs have not pleaded an unreasonably dangerous product. But basically, it goes through a number of legal precedents already talking about this sort of thing. And it says that the defendants claim, or they contend that the plaintiff's allegations are too conclusory, but the plaintiffs have provided significant detail regarding their allegations of a design defect. So, plaintiffs' allegations of fraudulent concealment, discussed at length above, are bolstered here by the allegation that FCA and its dealers specifically refused repair. Taken together, plaintiffs' allegations are sufficient at this early stage of litigation. Accordingly, FCA's motion to dismiss these plaintiffs' LPLA claim is denied. Now, the last motion to dismiss that the judge is dealing with here is a real big one. Now, the plaintiffs here, they're trying to bring a class action lawsuit. So as I understand it, how this works is that this class action needs to be actually certified by the judge. And once that it is certified, then other people can then sign up to be a part of this lawsuit across the nation. Essentially, anyone who's had kind of these cam and lifter failures, they could all sign on with these lawyers, be a part of this lawsuit, and then hopefully receive some sort of recompense from the manufacturer for it. So that's kind of the idea there. The judge is ruling on a motion to dismiss by the FCA lawyers who are saying that the plaintiffs cannot bring claims on behalf of putative class members unless they have standing to bring those claims themselves. Says when applied to the nationwide claims here, where adjudication under state substantive law would necessitate recognition of claims as specifically arising out of states other than those where the plaintiffs reside, plaintiffs lack standing to bring claims on behalf of a nationwide class. So as we've already discussed throughout this video, there is so many different laws on the different states as to how this sort of issue is applied. So they're saying, hey, look, you can't possibly say amongst all 50 states where the laws are applied separately that they would all apply here. The plaintiffs are only coming from 4 different states. So they can only really say, oh, this is where the laws are from the states that we are in. That's kind of their argument here. FCA lawyers go on to say that the plaintiff's insistence that this issue be decided at the class certification stage is unfounded on any binding rule. The court's reply says, though some courts, including this one, had delayed their consideration of the issue of standing until a motion for class certification is made, this order of decision-making is not rigid. Plaintiffs do not contend that they have standing to bring claims on behalf of consumers in states in which they do not reside, so plaintiffs' nationwide class allegations should be dismissed. Accordingly, FCA's motion to dismiss plaintiffs' nationwide class allegations is granted. Now again, actual lawyers here can contradict what I'm saying, but basically from what I'm reading online, this is the death blow for this lawsuit because being as how it can no longer be a class action suit, no one can sign up to be a part of this lawsuit. Essentially, you only have the 5 plaintiffs that started the lawsuit, and these lawyers are not going to become involved in a suit where they're just representing these people. Kind of their thought here was to get that class action suit going where as many people could sign up as possible, and then they would grow that pot and hopefully get a large verdict from the judge as far as the company paying them so that the lawyers would get a ton of money. Without having a large pool of people signing up for this, I don't think that's going to happen, and therefore I don't think the lawyers are all that interested in actually pursuing this case at this time. So in my opinion, this case is currently dead. I appreciate you guys watching. I know that was a lot of legal mumbo jumbo, but I wanted to provide you guys with an update to this case that I first brought to your attention 3 years ago. So I thought it was very interesting what the updates are to this point, and if there ever is a resolution, you'll probably hear about it here on Reignited.